Okay, we're in impeachment and rehabilitation out of evidence and specific contradiction. Like impeachment for incapacity or impeachment for bias, impeachment by specific contradiction is governed by no special provisions of the federal rules of evidence or its state counterparts. There is a judge-made restriction on such impeachment, though, most commonly called the collateral evidence rule. Sometimes it is referred to as the specific contradiction rule. The collateral evidence rule is confusing for reasons other than its varying names. Generally applies only to impeachment and by specific contradiction. And the distinction mode of impeachment and others can be elusive. Impeachment by specific contradiction consists of demonstrating that some particular part of what what a witness has testified to is false, and then suggesting that this gives the jury reason to disregard the remainder of the testimony. Sometimes this mode of impeachment is simply called impeachment by contradiction. It is best to avoid that terminology because it makes it easy to confuse this mode of impeachment with impeachment of prior inconsistent statements, which is sometimes referred to as impeachment by self-contradiction. The collateral evidence rule in most common formulation bars extrinsic impeachment by specific contradiction on a collateral matter. Here as elsewhere, extrinsic impeachment means impeachment through evidence other than testimony elicited from the witness being impeached. Because the collateral evidence rule applies only to extrinsic evidence, it does not restrict the ability of a party to impeach a witness by eliciting testimony on cross-examination contradicting part of the witness's earlier testimony. The trickiest term in the collateral evidence rule is collateral. Collateral in this context does not simply mean peripheral. It has a narrower technical meaning. As the materials below explain, the classic test for collateral matter under the collateral evidence rule asks whether the fact in question could be proven for any purpose other than contradicting the witness. A fact is collateral only if it fails this test. The material below also explain the traditional rationale for the collateral evidence rule, which is to avoid the risk that the trial will be derailed by inquiry into side issues. Whether the fact in question could be proven for any purpose other than contradicting the witness. So that's the meaning of collateral. If the answer to that is no. Simmons, Inc. versus Pinkerton's, Inc., 1985. Cudahy, Circuit Judge. Simmons, a manufacturer of residential and commercial bedding, owned a warehouse in Munster, Indiana, which it used as a regional distribution center for its products. In order to protect the warehouse, Simmons entered into a contract with defendant Pinkerton's, a national company providing investigative and security services, under which Pinkerton's agreed to provide uniform guard protection for the warehouse 24 hours a day, 7 days a week. A fire broke out in the warehouse and caused extensive damage. The Indiana Fire Marshal's office concluded that fire had been set as an attention getter by William Hayne, a Pinkerton employee assigned to guard the warehouse. Simmons then brought this diversity action against Pinkerton's and against the National Surety Corporation as surety for Pinkerton's. Pinkerton's argues that the district court erred in admitting Hayne's testimony that he falsely told a Pinkerton investigator that he had taken and passed a polygraph examination regarding the circumstances of the fire. After the fire, Pinkerton's asked Hayne to take a lie detector test in Chicago. he took the test, but apparently it was inconclusive for extraneous reasons. Hayne then agreed to take a second test in Indiana, but failed to make arrangements to do so. Nevertheless, Hayne later told Pinkerton's investigator that he had taken the second test in Indiana and passed it. At trial, over Pinkerton's objection, Simmons' attorney elicited from Haynes his testimony that he had lied about this matter. Although the rule in the Seventh Circuit is clear that admission or exclusion of polygraph evidence is within the sound discretion of the trial judge, U.S. v. Rummel, Seventh Circuit, 1981, for various reasons, this discretion has most often exercised in favor of exclusion. In this circuit, see page 215, as well as others. DeVries v. St. Paul Fire and Marine Insurance Company, First Circuit, 1983. Several circuits apparently exclude polygraph results entirely. Indeed, because of the perceived danger of prejudice, some courts also exclude evidence of a person's willingness or unwillingness to take a polygraph examination. For these reasons, Pinkerton argues it would have been error to admit the results that Haynes took as substantive evidence of the cause of the fire at the warehouse. The trial court did not admit Haynes' testimony as substantive evidence, however, but rather admitted it under Federal Rule of Evidence 608 B to impeach Haynes' credibility through cross-examination about a specific instance of his conduct, his lie about the second polygraph test, bearing on his character for truthfulness or untruthfulness. Pinkerton contends that this was an improper basis for admission because a witness may not be impeached by contradiction as to collateral or irrelevant matters elicited on cross-examination. Quoting U.S. v. Lambert, since the test for whether, which is the Seventh Circuit in 1972, since the test for whether a matter is collateral is whether the party seeking to introduce it for purposes of contradiction would be entitled to prove it as part of his case. And since Simmons presumably could not introduce evidence of the polygraph examination as a substantial part of its case, Pinkerton concludes that the collateral evidence rule precludes Simmons from impeaching Hayne in any manner that included a reference to whether he took a polygraph test or whether he passed such a test. We disagree, assuming arguendo that testimony relating to the polygraph exam was inadmissible as substantive evidence. Pinkerton has failed to note distinctions between this case and the authority on which it relies, which seem to make the collateral evidence rule completely inapplicable here. The rule apparently was developed in conjunction with a particular type of impeachment, impeachment by contradiction. Simply involves presenting evidence that part or all of a witness's testimony is incorrect. Thus, if an eyewitness to an auto accident testifies that the car that caused the accident was red, impeachment by contradiction relies on evidence that the car actually was yellow. The inference to be drawn is not that the witness was lying, but that the witness made a mistake of fact, and so perhaps her testimony may contain other errors, and should be discounted accordingly. Of course, a particular misstatement may or may not be probative of a witness's general accuracy, depending on the circumstances, and thus may or may not be worth the time it takes to establish it. For this reason, the collateral evidence rule developed. In the above example, assuming the color of the car was not directly relevant to any substantive issue of the case, for example, if the identity of the car were stipulated, it presumably would not be worth the fact finder's name to entertain a mini trial on the issue of the car's color, simply to prove that the witness was mistaken as to fact. Thus, while the accuracy of a witness's perception or memory can always be tested through traditional cross-examination techniques, The collateral evidence rule limits the extent to which the witness's testimony about non-essential matters may be contradicted by extrinsic proof. In short, if a matter is collateral, that is, if it could not be introduced into evidence as substantive proof, then it cannot be proven simply to contradict the witness's testimony for impeachment purposes. 3J Weinstein and M. Berger Weinstein's evidence, 607, and a bunch of other numbers in 1984. But the collateral evidence rule does not, as Pinkerton contends, limit the scope of all types of impeachment by cross-examination to only those matters that could be proven as a substantive part of the case. Rather, it merely precludes extrinsic evidence of certain facts that would impeach by contradiction. Various types of impeachment are allowed despite the recognition that the subject matter of the impeachment could not be used substantively, precisely because a witness's credibility is always an important consideration. Impeachment by inconsistent statement is one example. Another is the type of impeachment at issue here, an attack on a witness's character for truthfulness through cross-examination as to specific instances of the witness's previous conduct, which of course have not been the subject of his direct examination. Federal Rules of Evidence 608B, which governs this type of impeachment, is exactly tailored to strike the balance that the collateral evidence rule was designed to achieve with respect to impeachment by contradiction. Rule 608B allows cross-examination of a witness about specific instances of her past conduct, if probative of truthfulness or untruthfulness, but prohibits the proof of such conduct by extrinsic evidence. Thus, as with the collateral evidence rule, a relevant fact bearing on the witness's credibility, in this case, that he has lied in the past or acted in some other manner that cast doubt on veracity may, in the discretion of the trial judge, be considered sufficiently important and probative to be elicited on the cross-examination, yet, because of the dangers of confusion, prejudice, waste of time, and so on, that would be inherent in a mini-trial on the existence of that fact were allowed, extrinsic evidence on the matter is prohibited. Applying these principles to the testimony at issue here, it becomes obvious that the collateral evidence rule, in one sense now incorporated into Rule 608B, does not prohibit it. The testimony concerned an incident in which Hayne lied about having taken a polygraph examination. Whether or not Hayne took such a test or whether or not he passed may not have been admissible as substantive evidence. Nevertheless, in the discretion of the court, the specific instance of conduct in which he lied understandably considered probative of his character for truthfulness or untruthfulness. Therefore, it was proper to allow Simmons to inquire about the incident while cross-examining Hayne. Of course, had Hayne denied the lie, the bar on the use of extrinsic evidence of specific instances of conduct to attack credibility in Rule 608B would have prohibited Simmons from proving the lie through the testimony of other witnesses. This sort of proof, however, was not offered. Clearly, the testimony carried some danger of prejudice, and just as clearly, the trial court was obligated to balance this risk against the probative value of the testimony. The court did so, and we think it properly exercised its discretion in deciding that the testimony could be elicited under Rule 608B. For the foregoing reasons, the judgment is affirmed.